And with appointments, elected body of the government. What are the advantages and disadvantages? When you're ready, you may begin.
In Federalist 78, Alexander Hamilton defended judicial review by writing, "A constitution is, in fact, and must be regarded by the judges as a fundamental law. It therefore belongs to them to ascertain its meaning." Although the power of judicial review is not explicitly stated in the Constitution, judicial review is apparent in ideals outlined in the Declaration of Independence by checks to the power of the executive and legislative branches. Federalist 78 makes clear the institution of power to interpret law should come from an unbiased and just source, accountable to only the Constitution, something imperative to a functioning Republican democracy.
Hamilton was also correct in claiming that judicial review is a key part of maintaining checks on legislative power, to guard the Constitution and the rights of individuals from the effects of legislative invasions. Sparked by the Judiciary Act of 1798, Marbury v. Madison led Chief Justice John Marshall to inexplicitly dictate judicial review by asserting that it is emphatically the province and duty of the judicial department to say what the law is.
During the case, Marshall declared that Section 13 of the Act of Congress partially unconstitutional. Therefore, Marshall solidified the precedent for judicial review through rulings of the Supreme Court. Justice Marshall's reasoning is best illustrated in Windsor v. United States, where natural rights guaranteed through the Constitution and outlined in the Declaration of Independence are applied to equal marriage rights.
Due to the nature of judicial appointment outlined in Article 3, Section 1, life tenure is commonly held as controversial because Supreme Court justices are not held directly responsible to the public due to lack of election. However, life tenure guarantees Supreme Court justices a sense of job security and freedom of personal expression independent of public opinion in case decisions. The promise of life tenure during good behavior is founded in the colonists' resent of the British king making judges dependent on his will alone for the tenure of their offices.
In Federalist 78, Alexander Hamilton argues that the standard for good behavior for Supreme Court justices acts as a barrier to the encroachments and oppressions of the representative body. Life tenure creates institutional knowledge as best supported by the dissent of Justice Oliver Wendell Holmes in the 1919 case, Abrams v. United States, in which Holmes expressed an opinion directly contrasting of his previous majority-supported opinion in Schenck v. United States.
Life tenure also grants the Supreme Court the ability to operate independently of public opinion. In the recent Citizens United case, the public is largely unsupportive of the Supreme Court's decision, yet since the Supreme Court was held accountable only to the Constitution and precedents, public opinion in this case did not have any influence on the Supreme Court. Institutional knowledge permits unpolarized decisions, yet partisanship still occurs within the Supreme Court, as executives often appoint justices with similar political leanings.
Justice and executive shared politics are greatest exemplified in the recent appointment of Justice Sonia Sotomayor by President Obama. Life tenure can incur issues with outdated philosophies and a lack of adaptation to public opinion. Yet life tenure possesses benefits in the form of protection from political influence and public interference because justices are not elected. Critics of judicial review argue that judicial review is a direct affront to the democratic ideals of the United States government. Brutus 15 argues that the judges under this Constitution will control the legislative. However, the independence of the judiciary supports the philosophy of higher law.
This causes some to fear that the judges lose their sense of responsibility to the people they are charged to protect. Yet the ability for immunity from public opinion supports justices on making decisions based solely on their constitutionality. Best illustrated by Stenberg v. Carhart in 2000, justices' capability of making decisions independent of public opinion strengthens constitutional understanding in the philosophy of higher law. Unlike an elected representative, the only constituent the Supreme Court is held to is the Constitution and past court decisions. Thank you.
How has the 14th Amendment changed the power of judicial review?
The 14th Amendment has given a lot more power to Supreme Court justices because through the due process and equal protection clauses, they now have more power to strike down state laws that are contrary to the 14th Amendment.
For example, in Heart of Atlanta Hotel v. United States, the Supreme Court used the Commerce Clause to strike down legislation in Atlanta that would discriminate against certain ethnicities from staying in hotels.
From your stance in your argument, or in your opening statement, how would you respond to the question, should Nevada keep electing their judges or have the governor appoint them? How would your testimony respond to that?
According to our testimony stance, it would be better if Nevada decided not to elect their judges, because it ties the judges to the decisions they make and makes them responsible to the people, and that makes them keep their decisions in mind as they have to run for re-election, so they might not make the most constitutional decision in place of the one that the public would like.
Furthermore, serving as a justice is not a political position in the sense that they're not deciding political questions as the legislature does. They're making decisions based on the Constitution alone. So really it doesn't matter if the public has any influence on whether or not they're in office.
Also, judges in Nevada are not allowed to affiliate themselves with a certain party, which makes it more difficult for people to make choices because they are a separate categorization than other elected officials that the people vote for.
You guys keep on talking about the fact that the judges have to make decisions based upon the Constitution. Well, is it that simple?
It's not that simple, and something that comes into play is how these justices interpret the Constitution. And there are several ways that justices do this. So what one justice sees as constitutional, another might see as unconstitutional, based on the way they interpret the Constitution.
So if we have justices that are they have life tenure on a bench, should we get rid of those justices that have a different interpretation that's not as good? Like Clarence Thomas, for example, is an originalist or a textualist. Should we get rid of him, remove him from the court because we don't, like, his perspective is outdated?
No, because his view, although some may see it as outdated, still provides a more diverse interpretation of how a certain law fits with the Constitution and allows for the maximum amount of constitutional understanding among all of the Supreme Court justices.
What are the powers of the Supreme Court?
In Article 3, Section 2, the Supreme Court has original jurisdiction in all cases of law and equity under the Constitution.
The Supreme Court also has appellate jurisdiction on cases where circuit courts disagree. So, for example, something that's happening now is 2 circuit courts have disagreed on the issue of same-sex marriage. So it's now set to be heard by the Supreme Court.
So does that mean that every single disagreement goes straight to the Supreme Court and in that decision, and like the Supreme Court picks it up?
No, the Supreme Court still chooses which cases to hear, and the justices' clerks often make that decision, but once the circuit courts disagree, then it can be heard by the Supreme Court if they choose to use it.
Does the Supreme Court have any power to enforce their decisions?
The Supreme Court does not have power to enforce its decisions, but if the executive were to not enforce the decision, it would be somewhat of a political death wish. For example,
For who?
for the executive.
Okay.
For example, Andrew Jackson was a strong opponent of judicial review, and he often said that the court is making these decisions, but they can't enforce them. But he himself never acted contrary to any court decisions.
The Supreme Court does have writs of mandamus,
Damus.
which allow for the Supreme Court or the upper courts to give orders to lower courts or other government bodies which normally are used to set a time frame for a decision to be made, or for certain evidence to be for the status of certain evidence to be changed in the court.
What is the importance as well as the controversy behind a judge recusing themselves from a case?
Could you repeat that?
What are the benefits and potential controversies of a judge recusing themselves or not recusing themselves from a case?
The benefits of recusing themselves would be to remove any possible bias that they have, either politically or ethnically, anything that they have that could impact their decision other than the Constitution.
Has judicial review given the federal government too much power?
I would say that judicial review has not given the federal government too much power. It is a major check on the federal government because it is the only major check against the executive and the legislative working in unison to pass certain legislation. It holds the rest of the federal government to the Constitution so that nothing unfair can be put into action.
Furthermore, judicial review promotes the sovereignty of the people in that it prevents unconstitutional legislation being passed and then affecting the people. And since the Constitution was created by the people, upholding or striking down legislation that is unconstitutional preserves that sovereignty.
Judicial was so important that you guys have keep on reiterating. Why didn't the framers put that power specifically in the enumeration of Article 3?
The power. Go ahead.
Judicial review was intended to be an implied power, and the framers just took the idea from British common law, and they assumed that it would also be applied throughout the United States judiciary system without it needing to be enumerated in the Constitution.
For example, before the ratification of the Constitution, many state courts would strike down state statutes that were contrary to their state Bill of Rights. So this was judicial review on a state level before the Constitution was even created.
Give an example of that?
Not specific.
Find one. What checks does the Constitution have? Excuse me, what checks do the Supreme Court have on themselves?
By having 7 justices and the requirement of the majority to put forward a decision but still letting the minority support their own decision enables them to promote both sides to the public even though one is being put into place.
Also, amicus briefs can be a form of a check on the Supreme Court themselves because it allows the justices to have an understanding of what their possible ruling may have in affecting other outside parties non-related to the case. For example, in Schneider v. Phelps, many news stations such as CNN or Fox all inputted their justifications for why the Supreme Court should allow for the Westboro Baptist Church to congregate at the funeral of a Marine, because if they had ruled that it was unconstitutional, it would be a form of limiting freedom of expression.
Stop umming, Max. You're the king of ums.
I know.
I don't know about you guys, but I feel like you don't finish off what you're talking about. You like finish hand, you feel like you wanna say more, but nothing. You guys get that feeling?
Yeah.
Is it for all?
I know,
Well, because it's sort of your ideas as you're creating it. It seems like you haven't tied off your complete thought, and you still want to get back to where you left off, but then move on to the next question.
so you just haven't wrapped it up, you just haven't finished your answers yet, and I don't know if it's not because Andy's not here and you're just missing part of it, or it's just, it just seemed like every question, there was just more, you needed more to it, you just never answered it. I mean, you answered it, but the way your tone left it, that you had not completed it off. Does that make sense? Does that make sense? Does that make sense? Alright, just, it was all about your inflection in the way you were answering the questions. So, that's something I want you guys, I want you to watch the tape and observe yourself in those types of things. Chris, what do you got for me?
I feel you didn't answer the first bullet point question. I had to kind of just guess, like, oh, this is you agreed on